Hi everyone, I'm David Fisher, and this is Presidential Chronicles, a series of books and videos on American history as seen through the lives of the presidents of the United States. This episode is from the life of Andrew Johnson, and the focus is the president on trial. That's right, it's 1868, and there's a lot to cover in this episode because for the first time, a United States president has been impeached in the House of Representatives, and just a couple of weeks later, he's about to start trial to save his job in the United States Senate. A trial like this is really a numbers game. You need a majority in the House, that's it, to impeach the president, but you need a supermajority, 2/3 vote in the Senate in order to convict. Now, at the time, 10 southern states were still kept out of their seats in the United States Senate, so that meant only 54 members were going to be voting on this, and Johnson needed 19 of them in order to keep his job. Now, there were 9 Democrats in the Senate, and they were already siding with Johnson, and there were also 3 Republicans who had come out early also siding with the president. So that's 12. They needed 7 more Republicans to cross over and support the president in order for him to avoid expulsion from his position. Now, impeachment trials were not new. There have been impeachment trials in the Senate for judges, for other executive branch employees, but this is the first time a president. And per the Constitution, there was one significant difference between presidential impeachment trials and anybody else. According to the Constitution, when the President of the United States is tried, the Chief Justice shall preside. Chief Justice shall preside. Well, what did that actually mean? Well, if you want to look at the word preside, you can go back to the time of the founding. We found a dictionary, 1775, the Universal Etymological English Dictionary, that said to preside means to have an authority or rule over, to be the chief in an assembly. Sounds like a pretty powerful word, and we know from experience that's the case. Judges preside over trials all the time, and their word is final during those trials in almost all cases. There's other examples, like in political conventions, where the president of those national conventions, they would preside over those. They would make rulings all the time. So the word preside certainly has both definition and connotation that Chief Justice Salmon would actually be making some pretty significant decisions, and that was his intent. Chase was ambitious. He still wanted to be president himself. He expected to have a definitive role in this trial, rulings on witnesses and evidence. But then he got to the Senate and they balked at that because they pointed to a different provision in the Constitution that said each house may determine the rules of its proceedings. They get to decide what things like preside mean and what to do about it. Well, there's a bit of a conflict before the trial's even begun. And they worked out a compromise that wasn't very favorable to presidents. It basically said that the Chief Justice can make any ruling he wants, but that the Senate, by a majority vote, can overrule him. Hardly presiding in that case, it's more of just overseeing, and why sometimes Chief Justices have been referred to as potted plants, just sitting out there at the front of these presidential impeachment trials, because this has set a precedent that subsequent Chief Justices have all followed. Yeah, they can make rulings, but ultimately it's the jurors, the senators, the people who are going to vote guilty or not guilty, who had the ability to override all of those rulings, and that happened a bunch of times in this trial. 17 times Chief Justice Chase was overruled by the jury. Question of whether or not this was good for the Republic is a pretty good question, because this has been a precedent that has now been carried forward in presidential impeachment trials ever since. Well, the major players in this trial, in addition to the Chief Justice, were from the House manager's side. You've got Thaddeus Stevens, who was one of the leaders of the radical Republicans behind the impeachment movement. He was one of the managers, but he was old and infirm and really turned the authority over to Benjamin Butler, kind of a younger firebrand who was really going to be aggressive as the lead prosecutor in this whole thing. As for Johnson, his defense team was led by his Attorney General, Henry Stanbery, who actually resigned from the cabinet in order to take on this post. He also had a former Supreme Court Justice, Benjamin Curtis, on his team, William Evarts from New York, and a couple of others. Andrew Johnson was not about to sit back. He was a fighter. He wanted his team to fight hard. In fact, he was meeting with them basically every day throughout the trial, telling them what to do, to fight harder in this part of the trial or in that part of the trial. He even wanted to testify, to tell his own story to the Senate, and they talked him out of that part. But he was hardly a quiet bystander while this was all going on. Well, at the outset, the defense asked for a 40-day delay to prepare for the case. After all, remember, Andrew Johnson had been impeached over a weekend, and then 2 weeks later, they wanted to start the trial. Johnson thought that was unfair. Give me a little bit of time to get ready, and the Senate gave him some time. They gave him 10 days, not 40 days. The trial itself was pretty anticlimactic. There were packed galleries every single day, but those folks ended up mostly being bored. Most of the time in this trial we're debating procedural issues, the objections to Chase's rulings and the votes to override. There was a lot of that going on. The prosecution did actually call 25 witnesses over the course of 5 days, rested their case, took a 3-day break, and then it was time for the defense to begin in early April 1868. Benjamin Curtis opened up for the defense, and he really had 3 points to make. The first one in defense was that the Tenure of Office Act was unconstitutional. The president had the authority to dismiss Secretary of War Edwin Stanton, and there was nothing the legislature could do to usurp that authority that had been granted in the Constitution. So that was number one. Number two, the Tenure of Office Act itself was vaguely worded. There were ambiguities in there, and you can't convict somebody like a president over something that had such ambiguities in it. And then the third one came back to another definition, and this time the word was term, because the Tenure of Office Act, according to the defense, did not apply to Andrew Johnson, because it was Abraham Lincoln who had appointed Edwin Stanton, and according to the Tenure of Office Act, the law applied throughout the term of the person who appointed the appointee. In this case, according to the defense, that ended when Lincoln was assassinated. His term was over. According to Curtis, death is a limit, and Andrew Johnson started a new term, so it couldn't possibly apply to him since he had not appointed Edwin Stanton. Well, the senator said, no. A term is a term. Doesn't matter how many presidents sit in that office over a 4-year period. That's one term, one presidential term. Johnson was just finishing out Lincoln's term, so the Tenure of Office Act applied. You can see the wordsmanship that was going on back and forth. Ultimately, they said the jury would make that decision with their votes. Well, like we said, lots of rulings that went against the president. A lot of his witnesses were not allowed to be called. So the defense was eventually cut short. They went through a couple of weeks of closing arguments, so a lot of speeches, but not very profound. In fact, the case was relatively simple. Everybody knew what Johnson had done. The question was, did he violate the law? Did he violate a constitutional provision that merited impeachment? These were the things that the jurors were going to have to decide. Well, a couple of the Republicans did come forward as they were getting ready for that final vote. Remember, at the beginning, Johnson already had 9 Democrats and 3 Republicans kind of on his side. So would he have enough, though, to get to that not guilty number of 19 that he needed? William Fessenden of Maine was next up on the list to say, I'm going to side with the president. This is an overreach by Congress. It's not right. It's not fair. It's not a good precedent. I'm going to vote not guilty. John Grimes of Iowa was next, and he had something he specifically wanted from Johnson. He wanted to know that Johnson wasn't going to go into a retribution mode against anybody in Congress if his job was saved. Johnson gave him that assurance that he would not. And number two, he wanted this mess over at the War Department solved. He suggested to the president, go nominate somebody else that was confirmable. And so Johnson did that. During the closing arguments of the trial, he nominated General John Schofield to be the next Secretary of War. Thought this was a good thing because he was a favorite of General Grant's. And so that announcement on board, John Grimes signed up for a not guilty verdict. Well, 3 other Republicans came into line, but he still needed a couple of more. And the next one was a bit of a surprise, Lyman Trumbull. Now, Trumbull had put forward the Civil Rights Bill that Johnson had vetoed, sort of the start of this conflict between the president and Congress a year or so before. So kind of surprising that Trumbull would weigh in here on the president's side. But he looked at this as a really important precedent to set for the future, and he didn't like where this was going. Trumbull said that once set, the example of impeaching a president for what? When the excitement of the House shall have subsided, will be regarded as insufficient cause. No future president will be safe who happens to differ with a majority of the House and 2/3 of the Senate on any measure deemed by them important. What then becomes of the checks and balances of the Constitution, so carefully devised and so vital to its perpetuity? They're all gone. I cannot be an instrument to produce such a result. It was a brave move by Trumbull, and actually well said. Still needed one more vote, though. It's got to get to 19. Only 18 had come forward, and all eyes were on a congressman from Kansas by the name of Edmund Ross, a former colonel in the Union Army, and who was hounded by his colleagues and his constituents for weeks about this. Vote guilty, vote guilty. Well, Edmund Ross hadn't said. Either way, where he was going to stand, he was going to be a critical vote. Well, on May 16th, it was time to start that final vote for guilty or not guilty, and they decided to start with Article 11, the catch-all that basically said if the president had violated any of the parts of the other 10 articles, he could be found guilty in Article 11. They thought this was the best chance to get a guilty verdict. When they started, the court started calling the roll alphabetically, guilty, not guilty, guilty, not guilty. Everyone wanted to know what Edmund Ross was going to say when they finally got to the R's. Well, Ross was nervously sitting in his seat, supposedly shredding some paper into tiny bits that was folding up under his chair. What was he going to do when his name was called? Well, his name was called. He stood up and he very solidly announced, not guilty. Not guilty. Well, the rest was a formality. Andrew Johnson was acquitted on Article 11 of the impeachment charges. Well, the radical Republicans were distraught over this. They had fallen one vote short. They decided to adjourn the proceedings for 10 days, primarily because the National Republican Convention was being held at the time, and a lot of them wanted to go to that. General Grant was nominated to be president in those proceedings. A lot of lobbying was going on during this time. Colleagues to try to get people to change their vote, see if they could get a guilty verdict on one of the other articles. So when they came back, it was time to vote again. They started with Article 2. This is now on May 26 when the Senate reconvened. Went through that list, not a single change, not guilty by one vote. They tried Article 3, same result, not guilty by one vote. And at that point, they threw in the towel. Salmon, the Chief Justice, declared it over. Andrew Johnson, the president, had been acquitted by one vote. Well, Johnson had a simple response. He simply said, "It is not a victory for myself, but for the Constitution and the country." Many asked Edmund Ross, why did he make the decision that he made? And he had a really thoughtful response. According to Ross, in a large sense, the independence of the executive office as a coordinate branch of the government was on trial. If the president must step down, a disgraced man and a political outcast, upon insufficient proofs and from partisan considerations, the office of the president would be degraded, cease to be a coordinate political fabric into a partisan congressional autocracy. This government had never faced so insidious a danger, controlled by the worst element of American politics. If Andrew Johnson were acquitted by a nonpartisan vote, America would have passed the danger point of partisan rule and that intolerance which so often characterizes the way of great majorities and makes them dangerous. A very thoughtful response from Edmund Ross. This vote was perilous to those 7 Republicans who came on board and voted not guilty. Not any of them ever held a public office again. But one of them, Edmund Ross, earned praise about a century later. When John Kennedy wrote his Pulitzer Prize-winning book, Profiles in Courage, one of them was focusing on Edmund Ross. Well, there were still 9 months left in Andrew Johnson's term. Pretty uneventful, really only one major decision. It was a big one. Final amnesty for all Confederates. He had gone sort of in stages of giving amnesty for the Confederates, starting with the soldiers themselves, then working his way up. That was a blanket amnesty for all Confederates, including Jefferson Davis, the former president of the Confederacy, who had been held in jail for quite some time. He was now out on bail. Now he was free to go. As far as Johnson was concerned, it was simply time for the country to move on. Johnson decided to skip the inaugural of his successor, the only president to date other than one named Adams to do so. The fact is he and Grant were completely estranged. He was pretty bitter about Grant. He said that Grant was untrue. He meant well for the first 2 years, and much that I did that was denounced was through his advice. He was the strongest man of all in support of my policy for a long while, but Grant saw the radical handwriting on the wall and heeded it. I didn't see it, or seeing it, did not heed it. Grant did the proper thing to save Grant, but it pretty nearly ruined me. Pretty bitter, didn't show up at his inaugural. He also had some parting words for Congress, and you can imagine not very favorable. He believed that Congress had boldly betrayed their trust, broken their oath of obedience to the Constitution, undermined the very foundation of liberty, justice, and good government, and frankly, he had a point. Johnson went back to Tennessee, laid low, kind of quiet for a little bit, moved back in with his family, tried to get a little bit of time away from the spotlight, but he kind of couldn't resist himself. When a local Confederate soldier decided to run for a congressional seat in his district. He said, that can't happen around here. I'm going to take him on. And he ran for that seat, but Johnson lost. But that wasn't the last office that he went for, because in 1874, his name was up for the United States Senate, a chance to return there. The place that had almost convicted him just a few years before, he had a chance to now go be back in that body again. It took 55 ballots for the Tennessee legislature to make its decision, and sure enough, Andrew Johnson won. And he had a chance to take his seat right away because President Grant had just called a special session of Congress, and Johnson got to go. He was asked, well, is he going to have revenge on his mind? Well, he said, no, I have no wrongs to redress but my country's. My election settled all personal injuries inflicted. I come now to deal only with the present issues. In fact, he was pretty quiet on those issues. It didn't last very long, this special session. He gave one major speech, and that was basically just a denunciation of President Grant. Other than that, he was pretty quiet, and it was over pretty quickly. Johnson returned home. He joined his family. In fact, they were on vacation at the Stover farm, and after lunch on July 30th, 1874, he was chatting with his granddaughter by the name of Lily. Lily turned to leave the room, and she heard a thud. Turned around, Johnson was on the floor. He had fallen, he had suffered a stroke. By the next day, he had suffered a second stroke, and he was pronounced dead. Johnson had one wish for his burial. It was that let my body be shrouded in the flag of my nation and my head be pillowed upon the Constitution of my country. That wish was granted. His dear wife, Eliza, was laid to rest by his side about 6 months later. Andrew Johnson, on the one hand, lived the American dream. He started out the poorest of the poor in Raleigh, North Carolina. He found his way uneducated, but he found his way to self-educate. He taught himself a trade. He became a very proficient tailor, ran a good business, got involved in politics, basically held every office from the municipal level to the state level to the national level, House, Senate, Vice President, and eventually President of the United States. The American dream come true. But in many ways, this was also a nightmare for Andrew Johnson, the way certainly it unfolded during his presidency. His presidency, of course, has not been highly rated. In fact, most feel it was very poorly executed. They saw Johnson as a racist who was repudiating the victory of the Union in the Civil War, just handing back to the South the ability to degrade the rights of the freedmen who had just been given their emancipation by the 13th Amendment. But according to Johnson, he was going to wash his hands of all that, let the South kind of do whatever they want, have their black codes, elect Confederates. He was not going to interfere. This was decried both by the current folks as well as by much of posterity. Johnson was, of course, also criticized for violating federal law and getting impeached. After all, it's a pretty bad mark on somebody. And if you're a president to be impeached like that, he survived by just a single vote. His presidency has not been viewed favorably at all. But there's a counter to that, and it really falls in two areas. What was the plan for Reconstruction? And as far as Johnson was concerned, his plan was identical to that of President Lincoln. Lincoln had said many times, and we've talked about it in these episodes, that he wanted to bring the South back into the country as quickly as possible. According to him and Johnson, the South had never left the Union. Once the war was over, it was time to get them back into Congress, back up and running, full rights as states. And Johnson was inclined to do just that. He had states' rights leanings personally. He saw this as Lincoln's vision that he said he was committed to putting into effect. And whether right or wrong from a posterity standpoint, he certainly had good company. He was no Lincoln. He couldn't implement that policy like Lincoln could. He didn't have the political savvy to do it. But his approach was not different from what Lincoln was intending. As for the impeachment, well, look, what do you do when one branch of government tries to take over the whole government in a constitutional republic based on checks and balances? Because make no mistake about it, that's exactly what happened during the presidency of Andrew Johnson. The usurpation of authority by the radical Republicans in the House and Senate during the 40th Congress was unprecedented before or since. They kept the South out, so that gave them veto-proof majorities in both houses. They passed laws that were borderline clearly unconstitutional to clearly unconstitutional. Tenure of Office Act, by the way, was eventually ruled unconstitutional. It just took about 50 years to do so. Johnson was in a position where he was fighting for the rights of himself as president and future presidents, and was not going to give in to a Congress that was clearly violating his constitutional authority. If he was going to be impeached for that, that was okay with him, and that's why he fired Edwin Stanton. There are two sides to these stories, and Johnson did not conduct himself well in terms of gaining much popularity, but he had a lot of points in terms of preserving the integrity of the presidency, not only for himself, but for the future, because that is the bottom line victory in Johnson's presidency. Thanks to people like Edmund Ross, who braved their political future by voting to acquit him in the trial by one single vote, he stayed in office, and that vote really preserved the integrity of the three-branch system of government, the checks and balances that had been established by the Constitution. Some of that constitutional order came back into fold after being in a very tenuous spot for most of the last 4 years. That is Andrew Johnson and the President on Trial from the life of Andrew Johnson. For more presidential chronicles, check out my books on Amazon.com, and don't forget to subscribe to my YouTube channel. Until next time, I'm David Fisher, and this is Presidential Chronicles.